So let's go through your brief. Can you explain to people why you do think it does amount to a First Amendment violation, what Vulu did?
Well, what we tried to say in the brief is to take the politics out of this. This is really just a question of legitimacy of state power when it comes to putting pressure on private actors and their speech. And one of the things that we tried to point out is that these kinds of end runs around the rule of law and around the First Amendment have happened in direct proportion to First Amendment principles being defined and upheld. You know, when you establish what the First Amendment law is, one of the tactics that governments will use is to try and find a way around it, to say, this isn't a regulation. We're not restricting speech. We're just engaging in our own speech or something like that. And so the question is, when does informal regulation rise to the level of something that violates the First Amendment every bit as much as a law that was passed? Let's say New York State had decided instead they were going to pass a law that said no one can do business with the NRA because we don't like what the NRA stands for. Well, a direct regulation like that, a direct law like that, would be obviously unconstitutional because under established law, the state doesn't get to put its thumb on the scale and decide which viewpoints are acceptable and which are not. And so this was an attempt to see if they could achieve the same objective, but by informal means. And that's what we talked about in the brief, that there are many ways in which state governments, or actually government actors at all levels, try and put pressure on private actors to achieve the goal that they set out to achieve, but to do it without getting in the way of having the First Amendment get in the way of that. This is a principle that's long established in constitutional law. The basic landmark decision that was at the heart of this case is one from 1963 called Bantam Books versus Sullivan. And that's really the paradigmatic example of this kind of informal pressure that violates the First Amendment. And so the question in this case was, do the facts that were alleged in the complaint rise to that level?
Right. And obviously your answer was yes.
Yes, our answer was yes. And we tried to trace the history of that a little bit to talk about why this is so important. One of the things that led to Bantam Books, for example, was the fact that the Supreme Court during the period that led to Bantam Books had issued a number of decisions that were increasingly defining what First Amendment law means. In 1948, it decided a case called Winters versus New York that struck down a New York law that tried to regulate books, basically books that, in the words of that New York law, amassed stories of bloodshed and lust. Okay, and so that law was struck down in 1948, and it was a landmark decision then. About 9 years later, the court returned to the subject in a case called Butler versus Michigan that restricted access by minors to books, but it adopted a very broad law. And the court unanimously said the state cannot reduce adults to reading only what is fit for a child. And so as the court was getting clearer in drawing a line between what kinds of books the state could regulate, one of the tactics that arose from that were efforts to create these informal lists that were not enforced by law, but just recommended by members of government. You do have citizens committees being set up and so on. And this happened all around the country. Detroit had a very active process for this. But in Rhode Island, they adopted something called the Commission for Morality and Youth. And they would distribute a list of what they called inappropriate titles. And the commission would distribute those to bookstores in the state. And even though the commission had no enforcement authority, it couldn't sanction anybody for carrying those books. It could recommend prosecution under the state obscenity laws, but that's all it could do. But something else that would happen is that they would, the state authorities would send police officers around to the bookstores and just say, "Are you still selling these books on the list?" And so it wasn't a surprise that bookstores stopped stocking the titles that were on these lists. So again, it was not a
Right.
direct regulation of speech. It was this indirect nudge. It was indirect pressure. And
It was
the
sort of
court
an
in,
implicit threat.
I'm sorry?
It was kind of Bantam Books. It's kind of this implicit threat to bookstores, booksellers,
That's right.
that if they keep stocking certain books on this list, that maybe they'll get reported for violating obscenity laws.
That's right. And the court held that that was an informal prior restraint on the sale of books. And it was more dangerous than a direct regulation, because if you have a law that directly regulates books, you get due process, right? The state has to prove its case in court. You can defend and all of that. But this informal pressure comes with none of those procedural due process protections that you have with the direct application of law. And so these indirect measures that governments take to restrict speech are even more dangerous in a couple of ways. One, you have this just amorphous sort of threat hanging out there that is very broad and very vague. And then you also have no recourse to the protections of law if you've got speech that is targeted for suppression.
Right. There's no way to appeal on that. In Bantam
right.
Books, that
And
these
so
committees, there was no way to appeal their decisions or whatever.
And so this principle established in Bantam Books that informal pressure violates the First Amendment is very important, but has not been all that well defined in the 60 years since that decision came down.
And so how do you connect that to what happened in the NRA case?
The connection is you have state officials who are not operating under a direct grant of power, but they are using an intermediary, in this case, the insurance companies, and putting pressure on them to penalize the NRA for its speech. The goal is the same in both cases. As in Bantam Books, they wanted to suppress certain books. In this case, the NRA wants to suppress certain speech, and that is the advocacy by the NRA. And they are using a third party as the tool by exerting pressure on them of either promising leniency in the way they regulate the insurance companies, or simply in exhorting them and threatening them to stop doing business. That then leads them to undermine the NRA and in its business operations, and thereby restricting its message.
Right. And because the Vulu herself had this meeting, and she had said, if you agree to stop working with the NRA, we will look the other way on certain other violations you might have as a company.
That's right.
And then also she encouraged people in her letter, the other insurance companies in her letter, to keep in mind their reputational risks, right? Which is
yes,
which is something that she oversees, enforcement of reputational risk, making sure that they're managing that. That's something that she had within her governmental power to oversee. And was recommending that maybe the NRA, doing business with the NRA would pose such a risk.
Yeah, that was the argument. It was really the combination of things. If you look at particularly the meeting with Lloyd's of London, where the state was essentially saying that it would go easy on them if it agreed not to do business with the NRA. It had the guidance letters that, as you say, referred to reputational risk, but also entering consent arrangements with other insurers. And part of the conditions of the consent arrangements were not to do business with the NRA. This was then supported by a press release from Governor Cuomo, basically saying that doing business with the NRA sends the wrong message. All of this underscored the idea that the entire purpose of this had nothing to do with any banking regulations or any of the things that you think might be connected to the legitimate use of regulatory authority. Instead, these were all actions taken because the state disagreed with the political message of the NRA.